I am going to be chairing the first session under the title In Search for Supranational Notion of the Rule of Law. The European Union is based on a set of values and principles which on the one hand are common to all the member states and on the other hand are also particular to each. The values and principles of the Union are included in Article 2, which says that the Union is based on the values of human dignity, freedom, democracy, equality, the rule of law, and the respect for human rights. In terms of the value of the rule of law, some of its aspects are protected by Article 19 of the treaty, which, as the Court of Justice said, that value imposes jurisdictional national bodies and the Court of Justice the obligation of guaranteeing the full application of the law of the Union in all the member states and ensuring that rights are respected. Also, Article 2, Section A of the Regulation of 2022 on the conditionality regime declares that this rule of law will be understood, the value enshrined in the article of the treaty, which includes the principles of legality, which includes a transparent, democratic, pluralistic legislative process and accountable, of legal certainty, of prohibition of arbitrariness of the executive power, of including access to justice by part of independent jurisdictional bodies, also with respect to fundamental rights, of separation of powers, and non-discrimination and equality vis-à-vis the law. Nevertheless, this definition of the rule of law was established exclusively to the effect of the conditionality regulation and cannot limit the content of the notion of rule of law as a value recognized in Article 2, nor transform the notion of rule of law from a value of the Union, so clear in primary law, to a simple notion of a derived law. Values enshrined in Article 2, including the value of the rule of law, on the one hand, define the identity itself of the European Union as a legal regulation that is common with specific characteristics that, as the Court of Justice recognized in its sentence 2-3, in other words, the one on the Rome Agreement, has given rise to rules, principles, and relations that are mutually interdependent, which bind the Union and its member states, and the member states between themselves, which are committed in the process to create a closer and closer union before the peoples of Europe. On the other hand, values listed in Article 2 are values that are common to all the member states. As the Court of Justice stated in its ruling on March the 6th, 2018, the Union law is based on the fundamental premise that every member state shares with the other member states and recognizes that these share with it a set of common values on which the Union is based. These values, as they developed on the basis of the treaty and jurisprudence of the court, find on the one hand their source in the common values recognized and applied by the member states in their own regulations. And on the other hand, these are not simple declaration of intention of a political nature or just guidelines. No, these are values that are part of the identity itself of the Union and that are specified in legally binding obligations for the member states. More specifically, in terms of recognizing the rule of law, the court has declared that it is an obligation of outcomes that stems directly from the agreements and commitments of the EU states vis-à-vis other EU states and vis-à-vis the Union. To deal with the first subject of our notion, in search for a supranational nation of the rule of law, we have two great experts with us. Firstly, Markus Gehring, associate professor and former head of the Think for Legal Studies from Cambridge University, and Dimitry Kochenov, who is head of the Rule of Law Research Group in the Democracy Institute of the Central European University in Budapest and professor at this university in its law department in Vienna. Markus, you have the floor.
Thank you, Rosario. Thank you, Fundación Rafael del Pino and Universidad Carlos III. It's a great honor for the Center for European Legal Studies at the University of Cambridge to work hand in hand with you on this event, and we hope that this partnership will go on for a long time.
Spanish is not my native tongue, so I apologize to switch to English, which is also not my native tongue, but I am more familiar with. In this very short intervention, I want to highlight some of the rule of law challenges that we're facing at the European Union level. And I want to analyze them through perhaps unfamiliar lens. I'm proposing to look at them through the lens of federalism, because what we're experiencing in the European Union is not unique to the European Union experience. We will see that there are certain similarities that occur in all federal systems, where you have, on the one hand, in a multi-level polity with federal courts or central courts, overseeing the work of federated courts or periphery courts, the question of federal rule of law, which arises frequently and is frequently contested by those federated courts. The rule of law has many shapes and sizes in the European Union. One of the frequent issues raised in EU constitutionalization debates is the question of a single unified rule of law. In my view, rule of law is clearly present at the EU level, and the cases of the Court of Justice have shed important light of this federal understanding. The fact that it is not shared or just shared in outline in some of the member states, in my view, is quite normal in federal structures. In systems like the US and Canada, where federal courts operate in all parts of the country, in addition to state courts, perhaps the tension is very similar. We've seen most recently that once the US Supreme Court stepped back from insisting on the federal rule of law, as it did arguably in the recent case of Dobbs, state courts are quick to contest many more notions of the rule of law, such as free movement of citizens or even free movement of goods, as some courts in Texas have done recently. In my book, and I apologize, my employer owns a publisher, and my publisher always tells me to mention my book, so I've mentioned my book. In my 2020 book, Europe's Second Constitution, I highlight that this notion of the federal rule of law was very contested from the very beginning. You have the anti-federalist papers who really zoom in on saying you're taking away all the power from the state courts, you're overruling the state courts. And in a way, there was a question from the very beginning whether there is a single rule of law. Arguably, it emerged gradually. It grew over time. Because from the very beginning, there was a question whether the US should follow the English tradition with a strong notion of sovereignty of parliament, perhaps lessening the necessity of a strong rule of law, or on the other hand, the more Augustinian approach, which argues that unjust laws could never enjoy real legal force. So we need to acknowledge that different levels of the polity develop at different speeds, and the single rule of law at the supranational level for us in the European Union can grow over time. In fact, in a commentary on seminal EU cases, Justice Breyer, formerly of the US Supreme Court, noted that the European Court had demonstrated its role as the interpreter of the constitutional text of the EU treaties, finding that the Court of Justice of the European Union seemed far more familiar to US judges than foreign. More recently, the Court of Justice has expanded its rule of law jurisprudence. Courts of the member states are important for the European Union because they apply EU law and they effectively act as EU courts. The crisis arose when the very right-wing government in Poland decided to reform its judiciary and dismiss many of the longest-serving and arguably politically not sympathetic judges. The Court of Justice of the European Union has an extensive case law on enforcement of EU law by member state courts, ensuring that the effectiveness of EU law and the non-discrimination of EU law claimants are not undermined while ensuring national procedural autonomy. While the organized autonomy for the justice sector was guaranteed and no new remedies were normally required, there had been cases where the Court of Justice had criticized member states, making it more difficult for litigants to enforce their rights, or, for example, assigning all subsidies cases to a single local court. But the Polish situation was qualitatively different. It undermined the independence of the judiciary, and that is a serious challenge to the single rule of law. And the court relied heavily in its case law on the Portuguese judge's case, and the court built the relationship between it required not only the EU level judges to follow the rule of law, but also the member state judges, and it invoked Article 19.1 of the Treaty on the European Union, and an article that I think we will come back to in the discussion. But it's interesting to me that the Court of Justice in the Polish judges' independence of the Supreme Court case, so Commission and Poland independence of the Supreme Court, the Grand Chamber went one step further. The court ruled that Poland had violated EU law by trying to remove the judges from its Supreme Court. And Poland had argued that the organization of the judiciary is not within the competence of the European Union? And the answer is very instructive, and it relates a little bit to the situation in the UK, because the case that we regard as seminal, the Whiteman case, was a case on Brexit. It was cited in the decision, right? EU law being based on the fundamental premise that each member state shares with all the other member states, and I think Rosario already referred to this, recognizes that those member states share with it those same values. That premise both entails and justifies the existence of mutual trust between the member states, and in particular, their courts, and that those values, sorry, Germans can't say W, upon which the European Union is founded, including the rule of law, will be recognized, and therefore that EU law that implements those values will be respected, right? Clearly emphasizing the shared values and the notion that while you have complete procedural autonomy on how you organize your judiciary, you can't do it in a way that undermines fundamental values of the European Union. So by requiring the member states to thus comply with those obligations, the European Union is not in any way claiming to exercise the competence itself, nor is it therefore contrary to what is alleged, to what was alleged by Poland, arrogating that competence. In other words, even though Polish law was struck down by the Court of Justice, it underlined that while there are substantive obligations on the rule of law, the competence of the member states to organize their judiciary is not abrogated. That is, the court ensures a common rule of law, but does not dictate the concrete decision to be taken by the member states. In conclusion, the fact that different member states and their courts have different opinions about the shape of the rule of law and the appointment and independence of the judiciary in particular does not undermine the quasi-federal system that is the European Union. Thank you very much.
Thank you, Markus. Ahora le doy la palabra.
Thank you very much, Markus. Now, Dimitry, you have the floor.
Presenting a living example of what we're talking about, because I'm a professor at the Central European University, which was kicked out by the Orban government because he didn't like the only US accredited private school teaching in the middle of Budapest. So every Monday I take a train to Vienna, because all the students are in Vienna they are not allowed to come to Hungary, and all the diplomas are issued in Vienna. And there is an interesting footnote. The European Union actually won a case against Hungary at the Court of Justice about precisely this set of affairs. So although the case was won, there was nothing that was felt as a result on the ground. On the ground, the university is exiled, and the campus in the center of Budapest is empty. So this is something that the Princeton professor Kim Lane-Shepard calls losing by winning. And the European Union has been very active in losing by winning. But I don't want to make it a negative story. So even though my university is just one example among hundreds and hundreds and hundreds and hundreds of similar cases, the fact of the matter is that the European Union is not anymore a union of rule of law abiding democracies. It's simply a fact. If you look at Poland, it will be difficult to fantasize that there is really rule of law on the ground if the fake court, which is branded as the Constitutional Court, tells us that it is not bound by Article 6 and other articles of the European Convention on Human Rights, and that it doesn't honor the supremacy of European Union law. This is not the rule of law for you. And Hungary is even worse. If you look at all the indices on democracy, all the indices on the rule of law, these countries have been falling steeply throughout all the years that the current governments have been in power. So the European Union has to find a way to deal with the current situation, which is new and which was not envisaged. Because what the European Union comes across from the moment of its very birth is a very hopeful union that precisely presumed that this situation that we're experiencing now will never be a real situation on the ground. So the challenge is new. And this new challenge has been tackled by all kinds of institutions at all the levels, including the Court of Justice, which I suggest prompted something that we can call a legal revolution, a constitutional revolution at EU level. And that revolution is precisely, it consists precisely in taking the rule of law and democracy as well as human rights much more seriously than before. So from the Portuguese judge's case on, when the Court of Justice finds competence using Article 19 as a pretext to deal with the issues of the formation of the judiciaries, what Markus already mentioned, we see an opening of a floodgate of absolutely new kind of understanding of European Union law at the supranational level and also on the ground. Let's compare this new law with what the law used to be at the moment when Poland, Hungary, and all the other Central European member states acceded to the Union. Back then, the Commission felt that it needed the Copenhagen criteria, political criteria, so-called, about the rule of law, about democracy, about all what we find in Article 2 today, next to the requirement to strictly adhere to the back then acquis communautaire. Which means that structurally, all these values were not actually regarded as fully belonging to the core of European Union law. Otherwise, we would simply not need the extra set of criteria. And indeed, this is what we see in the case law of the court. The fundamental starting point for the rule of law is the case of Lever, where the court essentially says the communities are a rule of law system because everything that is done here is based on law. Well, if we look at the academic literature, this has nothing to do with a working definition of the principle, because it's absolutely circular. This is exactly the understanding that the Orban government uses, because the Orban government has never violated a single provision of national law. They simply politically abusively, they rewrote the constitution, and then they changed all the laws as a consequence of this absolute reshuffling of the legal system. So with 700 new laws, even more, and the new constitution, they could hijack the system and absolutely destroy the rule of law by legal means, which means that a different understanding of the rule of law is obviously required. Of course, we have a totally different situation in Poland, where they don't care about the law on the ground. They don't care about the constitution. They openly violate it by appointing the judges who are then recognized by the Court of Human Rights in Strasbourg as fake appointees, by not caring about European standards, and by actively signaling to both the Strasbourg system and the European Court of Justice that they don't actually care what those courts have to say. Nevertheless, this constitutional revolution, which is to the credit of the Court of Justice, has resulted in a total redefinition, rethinking of what the European Union is about. So now the European Union is not only a set of promises which come on top of the assumption that the law will, that the basic values will be preserved. It's also a set of rules which are based on EU competence, which are based on the newly emerging substance of the meaning of the rule of law, as a result of all this case law related mostly to Poland, but also to Hungary, also to Malta, and also to other countries. And it's also the enforcement mechanisms, including interim relief standards. So now the European Union clearly has a lot to say about the rule of law. And to my mind, this is something that we should celebrate, because the European Union is definitely strongly reinforced as a result of this fundamentally flawed set of circumstances when it suddenly discovers that it is not what it believed it was. That suddenly not all the member states are what all the member states promised to be. And here the negative side of all these positive stories starts. I mean, of course, there are negative stories in Hungary, in my own school, and in Poland. But once we start looking at the supranational level, let's ask ourselves, so this constitutional revolution is good for the textbooks, it's wonderful for the self-glorification of the Union, but has it changed anything on the ground in Poland and in Hungary? And here losing by winning becomes the main principle. In fact, if we look at the elections in Poland and Hungary, Orban won a much higher majority through abusive electoral laws, through a total abuse of European Union funds, through making 1 million extra citizens who are all on secret lists and who all voted for precisely the government over the last less than 10 years. So, and it's a country of less than 10 million citizens. So what we see is that this kind of constitutional revolution has not resulted in any change whatsoever. Then where is the change? And the change is at the supranational level. So the European Union, especially the Court of Justice, come strongly reinforced as a result of this newly found competence and newly found reinterpretation of all the values as a fundamental part of EU law. And here the most important questions start, because once we start testing the application of the newly discovered substantial principles of the rule of law against the treatment of the Court of Justice itself, in the cases concerning itself, we find the void and the deep discrepancy between what the Poles and the Hungarians are expected to do and what the Court of Justice is expected to do and is bound by. So it's like Professor Weiler's soldier's principle, or rather the officer's principle. Do what I say, but don't do what I do. And the case law is piling up where numerous questions arise about the rule of law nature of the Union as such at the supranational level. So the first, of course, we are all familiar with the first the first signs of worry, like the opinion 213, where the Court of Justice gives an instrumental reading to the very idea of adherence to the value of human rights protection, placing it in the context of the complexity of the federation itself. Again, connecting with Markus. This is something that the Strasbourg system was precisely designed not to do. You are either bound by human rights or you are celebrating your own constitutional Sonderwerk. And the European Union chose the second. And then once this floodgate was open, we see plenty of bells ringing. And here I will only cite two cases. In the most recent puzzling development, the Court of Justice accepted a preliminary reference from a gentleman dressed as a judge, sitting on a Polish bench as a panel of one, who has already been declared unlawfully appointed by the European Court of Human Rights. And we are told that this is necessary in the interests of constitutional dialogue between the local judges on the one hand and the judges at the supranational level on the other. But the fact of the matter is that this flawed quasi-appointee was in fact not a judge in the eyes of any law-abiding court anywhere in the European Union, but the Court of Justice, which is not bound by that system as a result of 213, opinion 213, and as a result of its own wayward readings of Article 6 CCHR, which doesn't bind it directly. So the Court of Justice accepts a question from someone who is not a judge in the interests of the judicial dialogue, thereby siding with those who attack lawfully appointed judges in the Polish legal space, and sending a very strange signal. And then imagine what happens once the answer returns to the Polish level. Anyone who actually considers the judgment rendered by that non-judge, as we know from ECHR principles, has to be ignored by all the judges in the European Union because they are bound by Article 6. The Court of Justice is reinforcing this conundrum for no reason whatsoever. And it would seem for no reason. But in my scholarship, including with Professor Butler, who is in Sweden, we suggest one of the reasons why the Court of Justice behaves like this. And here the crucial pointer in absolute disregard of any kind of substance of the rule of law at the supranational level are the Sharpston cases, where an advocate general sitting on the bench was kicked out by political decisions of the masters of the decision of the masters of the treaty, and the Court of Justice, in direct violation of the core principles formulated for Poland and for Hungary, as well as in direct violation of ECHR case law, via a vice president, has this exactly it was our dear panel member dismissed the case by claiming that the Court of Justice actually doesn't need structural independence as a court. So if you lack structural independence, it means that you cannot actually give fuller meaning to Article 6 and adherence to the Strasbourg system because you will not qualify under Article 6. So then if you are not a court under Article 6, given that the member states can do whatever with the bench and the law doesn't matter and the court doesn't even want to look at the law as the vice president dismissed any kind of legal arguments, which is, I think, one of the most shameful opinions the Court of Justice has ever rendered, what we have as a result is that there is an overwhelming flood of cases from unlawful appointments at the national level, which is now possible because the standards of the rule of law at the supranational level and at the national level are radically different. So the Court of Justice has done an immense job in making sure that there is a substantive standard of competence and also on substance of the rule of law at the supranational level, as opposed to just Copenhagen criteria, but at the same time, it has absolutely failed the promise to apply the same standard to the supranational level. And this failure of the promise was very well noticed in the capitals, especially in Hungary and especially in Poland. Because now the treatment of the unlawful judges in Poland is radically different in Strasbourg as opposed to Luxembourg. And this is extremely dangerous for the Union as such, because the Union has to be bound by exactly the same principles which stem from Article 2, and this is something that the treaties require. So then, to conclude, I think in order to make significant progress on the rule of law on the ground, so far, as my university testifies, there has been no progress. We need to think about the level of adherence to the rule of law at the supranational level. So when a system is such, when one of the members of the court is known to have been appointed unlawfully, which was the case with the Greek so-called advocate general for 1 year, then the floodgates of illegality are opened by the vice president and other members of the court. Also when we apply the same standards to the national level. And then the final outcome of all this is that it is very difficult now to speak of the Court of Justice as a court which is fully on the side of the abused judges in Poland, because the radical difference between the Polish Supreme Court and President Gersdorf standing on the side of the judges who are being abused and the Court of Justice of the European Union with President Leonards and the Vice President failing to take the side of Advocate General Sharpston is radical. It means that the Court of Justice is the court that has also betrayed its own member, actually notable member. And this is a lesson that has been learned in the wrong capitals, if I may say so. Thank you so much. It was an honor.
Bueno.
Right. I don't agree at all with what was said. I'm not going to respond because this is a decision that I have made myself. These are rulings in which I myself have participated, so I'm going to abstain. Perhaps, Markus, you can come and define our court after what we've heard.
I agree that defending the rule of law is a challenge for all tribunals, especially in the face of very serious challenges, particularly from member states such as Hungary and Poland at the moment. Where I disagree with Dimitry, and he probably knows that, is when he says in the Ghent and Nobel Bank case, the Court of Justice should have just dismissed the admissibility of the prima reference from a judge from the Polish Supreme Court, arguably wrongly appointed, right? I think we can all agree on that, and we have judgments to that extent. But what did the Court of Justice actually do? The Court of Justice didn't just accept the admissibility of a prima reference question like it normally does. It actually set out a whole regime of legal tests that have to be met by the referring judge. And then in the end concluded that exceptionally in this case, which after all was a case about consumer protection law, it could accept the admissibility of a prima reference question despite the questions about the legality of the appointment. Anything else, in my view, the alternative would be to dismiss all cases coming from Poland. I don't think that's a viable alternative. He is right, and Catherine and I are good friends and colleagues of Eleanor Sharpston, Leo Sharpston, who was a long-term colleague of ours in Cambridge before she became Advocate General. But the fault, in my view, is not with the Court of Justice and the application of the rule of law to its own court. The fault lies plainly with the British government. The British government has secured the continuous leaving in office of all EU officials in the withdrawal agreement. It forgot or deliberately not included the advocate in the judge in the Court of Justice and the General Court. Why not? I would argue because the British government, the very conservative Brexit government, did not like having European judges, having a European Advocate General in the court. So to then say you've sort of muddied the waters by applying these criteria to your own court when the blame really lies with the member state that somehow, and to my great regret because I live and work in that member state, decided to leave the European Union, is I think slightly unfair. But otherwise, I agree. And you know, coming from Germany, I must admit, we are at a very dangerous juncture, right? If we do not defend, as Professor Moreno said, if we do not defend democracy and the rule of law, we can end up in a really dark place, right? And I think that's where I see the strength of the European Union and European integration, to hold even the Polish Supreme Court to account and to say, we recognized that there are questions as to how you were appointed as a judge, but exceptionally we'll accept a question. Granted, it could have perhaps taken a different view in Ghent and Nobel Bank, but I think we need to recognize also the limitations of what is the function of the Court of Justice and the Luxembourg court here. Thank you.
Fine. We can begin the second round. Thank you.